restrict electronic media coverage of a court proceeding, the party must file a motion under Rule 4-401.01 no later than 10 days before the proceeding. The motion must address the particular circumstances of the proceeding and be no more than 4 pages in length. The opposing party may respond to the motion no later than 5 days before the proceeding. The response is limited to no more than 4 pages in length. Any reply must be filed no later than 3 days before the hearing. The reply is limited to 3 pages in length. No oral argument on the motion will be held. The court will issue an order before the proceeding, and if the request is denied, issue particularized findings denying the request. The evidence presented at the April 17, 2026 hearing and all arguments already in the record are preserved. This is the order of the court. This concludes the reading of the second ruling of this court. All right, counsel, what I want to turn to next is addressing the outstanding motions. As we are vacating the preliminary hearing, which is set for, I believe it's May 18th, the week of May 18th, that frees up time to address outstanding motions. And the court wishes to make best use of the time as you were previously scheduled to be there. So I'll turn to the parties to hear from you in determining if the parties will be prepared to address the motions that are outstanding. Turning to a defense.
Your Honor, I believe, are you talking about the ones that have been fully briefed at this point?
That's correct, or anticipated to be fully briefed before that week begins.
Yes, Your Honor, we can be prepared to do that.
All right, and to be clear, do you want to put on the record the motions that you wish to address at that hearing, just so all parties are on notice and we know how we're proceeding?
Give me just a minute, Your Honor, and I'll pull them up. I know one of them is the motion for the order to show cause and compel discovery. I know that one is pending right now. Just 1 minute, let me pull them up.
Kathy, while you're doing that, Your Honor, I show 3 outstanding motions. The one is the motion for an order to show cause and contempt. That is fully briefed. I believe that's ready to be argued. Actually, I think that's a notice to submit without argument is how it's been submitted. The second is motion to close the preliminary hearing and seal exhibits. That was filed May 1st. We intend to use the full 2 weeks to respond. If the defense intends to reply, the reply will be, I believe, the 21st, which will be the day before the current preliminary hearing dates end. So I don't know if they intend to waive that reply time and argue at that time or not. And then the final one is the recent motion the defense filed to find the use of hearsay at the preliminary hearing unconstitutional. We intend to use the full 2 weeks to respond to that. It also hasn't been served on the Attorney General's office, so that one will not be ready by the time of our preliminary hearing dates. We're going to have to find another date for that. We've also objected to the motion to close the prelim and seal exhibits because our objection is that it's not specific enough. We don't know which exhibits that is. So that issue needs to be resolved too before it can actually, from our view, be argued and decided upon.
All right, thank you, Mr. McBride. Turning to Ms. Nestor.
I do think we were waiting on their supplemental exhibit and witness list, which we have received. I don't know if they're still going to update it again, but that's one of the things we were waiting on before we identified which matters needed to be sealed in the preliminary hearing. So I know we could perhaps get together and talk with the prosecution about whether they anticipate adding any additional exhibits And then we can probably specify which exhibits we think, but we have to leave it open because we didn't have their final exhibit list until within the last, I think, 2 days. We would be prepared to argue the motion to show cause and the motion to close the preliminary hearing. I do believe we either have, and I would defer to Ms. Visser, I believe we either have served the Attorney General or we are just about to serve the Attorney General, but I do anticipate that one might not be ready to argue by the week of the 18th. That one probably, I would agree, may need an additional, an extra date, but it would need to be heard prior to the preliminary hearing because it deals with whether some of the 1102s can be presented at the preliminary hearing.
All right. So my understanding is it sounds like the parties will be ready for defendant's motion in limine to close portions of the prelim. Is that correct?
Yes, Your Honor, and we will, we can supplement with specific exhibits now that we have their final exhibit list, I believe. I'll talk with the prosecution and our team, but I believe we can supplement that.
All right.
Chad Grunander, I'll add on to that. If it is supplemented, Ms. Nestor, it would probably need to be done rather quickly as the preliminary hearing dates or the previous dates are a week from Monday. And we would like the time to brief that and be on appropriate notice. I would imagine the media would have similar concerns, but so Judge Graff, I'm not entirely sure if we'll be prepared to argue that motion on the dates that are open for Your Honor, but we can work towards that.
I knew they were going to let him go. Poor guy.
Still doesn't know how to use AI. Honestly, lasted longer than I thought.
And may I add, Your Honor, this is Jeff Gray.
Yes, Mr. Gray.
Notice to the Attorney General's office. They may choose or may not choose to respond. They're not required. They're required the particular notice, and we'll be talking with them. If they're satisfied with our response, they may choose to stay out of this at this point, but we still need to consult with them.
I also, Your Honor, just want to make clear, we don't necessarily, we serve the Attorney General out of an abundance of caution, but we do think since it involves a rule of procedure, it may not really be required to serve the Attorney General under the statute, but we did it just out of an abundance of caution. So I don't want to make it look like we're conceding that notice is required, although we are doing it.
I see.
Certainly our position is that it is required.
All right. Well, I appreciate the parties sharing their views. Well, let's go ahead and tentatively address the motion to close the preliminary hearing, and we'll address that. How does May 19th at 10 a.m. look for the parties?
Your Honor, the defense was planning on being available the whole week for the preliminary hearing, so I feel fairly confident that my team is going to be available on that day.
All right. To the state?
Oh, Your Honor.
All right. We'll go ahead and start at 9 a.m. on that day. And just to set the expectations, we'll plan on a 3-hour hearing, so from 9 to 12, and so I would ask that that you're fully prepared to go forward at 9 a.m. And to Ms. Nestor and your team, is it your request that Mr. Robinson be present physically in court?
Yes, Your Honor.
All right. All right.
Your Honor, this is Jeff Hunt. The media will want to be heard on that motion. I believe Mr. Judd is online, and he will be taking the lead on that. I'm not sure of his availability that day.
All right. Mr. Judd.
Hi, Your Honor. I am here. And yes, I'll make myself available that day. I did, without taking any more of the court's time than is necessary, wanted to talk about one small detail. I appreciate the court's ruling saying that under the new order being entered today, a request to cover a hearing would need to be submitted 14 days in advance. That would only create problems, I think, with the one we're talking about today.
Right.
I wonder about a request to do that. If the media were to submit that as soon as they could get their ducks in a row collectively, would that be enough for the court in this case?
Yes, and I recognized when I was drafting the ruling that the one conflicting date would be this upcoming one. So I would request that the parties file. Well, to be fair, until there's a request from the media to cover it, that wouldn't even come into play. Theoretically, if they choose not to file that, that becomes moot. And so, for this hearing only, as soon as that's filed, please file anything that you wish to be considered as soon as possible to allow the other sides to reply. So please don't wait to the day before. If it's filed, I would say within 48 hours of the filing of media, the request for electronic media coverage, within 48 hours, parties who wish to file, please do so. Thank you, Mr. Judd. I appreciate you addressing that. The court's obviously going to be flexible about that issue, given the short turnaround.
Thank you.
Judge Michael Burt for Mr. Robinson. Could I raise one issue concerning the court's order on the procedure going forward? Is the court requiring that we be notified of the requests, or do we have to get that from the docket? Given the short amount of time that we'll have to respond, I'm wondering if the court would consider ordering, if it hasn't already done so, that we be provided notice of any request when it's filed.
Well, wouldn't you be receiving, do you receive notice when the request is filed on the docket?
Only when it's issued by the court, Your Honor. We don't receive notice of the requests.
I see. Well, let's see here. That is a good question, Mr. Burt. I appreciate you asking that. Let me just take a look at what options we may have to address. Well, on the onsets, we have the deadline. I mean, given the deadline set by the court, there's a timeline in place. And so I would ask the parties to be cognizant and take a look at the docket on the date when that deadline is approaching. So for now, please refer to the docket. If this becomes an issue, please let the court know. But I would ask the parties to be diligent as you have been in the past. And when you see that hit the docket, if you wish to file, you certainly can.
Thank you.
And this is Ms. Nestor. I do have one more clarification. So the motion of the order to show cause, can we not just argue that the same day that we argue just because of the travel and expense to the county? I'd like to try to do that at the same time. We did file a notice to submit, but we've not waived argument on that.
Let's see here. I wanted to pull up that motion briefly. There's a few things on the docket, so it takes just a little bit to get there.
No worries, Your Honor. I don't anticipate there would be any testimony at that. It would just be argument. So we shouldn't need too much more extra time.
All right, I see. One moment. So what you're saying is you're not requesting an evidentiary hearing. You're simply requesting oral argument. Is that your understanding?
That's correct, Your Honor.
Well, I believe that the procedure is that if I rule on the motion and I grant it, we do need to take an evidentiary hearing because sanctions are being requested. And so I would want to follow the procedure. So it would necessitate an evidentiary hearing, not just oral argument.
That would be my understanding. That would be later. So this is just a hearing to determine whether or not to set the evidentiary hearing is my understanding. So yeah, right. So that would be on a later date.
Okay. Well, we can address oral argument for that, and then the court will make its ruling and take it from there. Obviously, I'm not weighing in either direction. I want to consider everything that's before me, but we'll set the oral argument as well on that same 19th date and address that issue as well.
Thank you, Your Honor.
Anything further from the parties?
I don't think so.
All right. Thank you to all parties for being here. This concludes.
All right, that update there coming from the Charlie Kirk murder involving Tyler Robinson. Our colleague Josh Breslow putting on X, the judge denies motion from accused Charlie Kirk assassin Tyler Robinson to ban cameras and electronic media from the courtroom. Media coverage will continue. Preliminary hearing is set for July 6th through 10th. Judge Tony Graff pushing the accused Charlie Kirk assailant Tyler Robinson's preliminary hearing into July and rejecting a bid to ban cameras from the courtroom, marking a significant pretrial development in the high-profile case. Like on your screen you're seeing, we learned that preliminary hearing is moved to July 6th through the 10th. All right, we wanted to be sure to bring you that live here on Live Now from Fox. It's time for us to step away for a quick 2-minute break. We'll be right back with much more on the other side. Stay close.
I just created a $47 ebook in 3 minutes flat using AI. Time me while I do it again. Already in design.